Just because other people are doing it doesn't mean you have to do it. We say it about alcohol, we say it about drugs, we say it about long distance running. We should be saying it about trusts. I'm Simon Jenga and welcome to Simon Says. Now the purpose of this video is to cover off trust basics. We're going to be talking about key definitions, how a trust operates, when you might need a trust, and when you should get one. It's about legal literacy, not legal advice. Because knowing your legal position is half the battle, and hopefully you'll take a few things away from this video to help you on your journey. Enjoy. Welcome along. Thank you for coming. Thank you for those that are tuning in online, and thank you for those who are watching or listening at a later date. My name is Simon Jenga. I'm a director at LOA Law, and we are a general practice law firm that cover everything including trusts. So today we're going to be going over the basics of what trusts are, why you should have them, and when to get them, or when's the best time to have them. So that's kind of the guts. Really the purpose of this is to go through the real core basics of a trust. Often in my experience we jump to why we need trusts and get into the real detail of the application of trusts without understanding the basic side of it. So the purpose of today is to really go through those basic building blocks and learn a bit more about what makes up a trust. So we're going to go through what is a trust, we're going to cover the key terms of a trust, what powers exist, what the trust fund is referring to, and then the rubber hits the road. Why have a trust and when to form a trust? And then there'll be some time at the end for some questions. For those online, you don't get the benefit of this, but for those in the room, we'll have a bit of a Q&A at the end. Otherwise, questions throughout is not only allowable, it's encouraged. So, first of all, everything that we talk about today is not to be taken as legal advice. This is just general information about trusts. If you have something specific that relates to your circumstances, then please talk to your existing lawyer. Or if you don't have a lawyer, then talk to a new trusted legal advisor, and that might be us or that might be another law firm wherever you are. So, what is a trust? Now, a trust is different than other entities, like a company, because it's not actually an entity, it's a legal arrangement or a legal relationship. And what I mean by that, and this is an example I'm going to come back to throughout our little chat, is it's basically someone holding assets for the benefit of someone else. So an example that I like is my friend is going overseas, they give me $1,000 to look after their dog. So they've given me the $1,000 to hold solely for the benefit of looking after the dog. The dog is the beneficiary. I am the trustee because I'm holding the value or the cash for the benefit of the dog. And my friend is the settlor because they are the ones that have given me the cash to benefit the dog. And that is the basis of every modern trust in New Zealand, basically. That idea of holding assets for the benefit of someone else. So there's 4 different types of trust that fit into that kind of general criteria. The first is discretionary trust, and this is our traditional New Zealand family trusts, what we know and love and what everyone thinks of when they think of a trust. The reason it's discretionary is because no one has a fixed interest in the trust assets. So all of the beneficiaries, although they are entitled to be considered for a distribution, they're not actually entitled to the assets of the trust on any given day. So it's 100% at the discretion of the trustees whether they make distributions to those beneficiaries. So that's kind of our common family trust. The second type is a fixed trust. Now fixed trust, as the name suggests, is completely different than a discretionary because it has fixed interests. So an example of that might be a trust that says that when the children turn 25, then the trust fund must be distributed equally between them. And that's a fixed interest, which means that if any of the kids have already turned 25, then they are entitled to their share out of the trust fund, whether the trustees want to give it or not. So that fixed trust, it could be a trust that is itself fixed totally, or there could be fixed interests within a trust. So what I just gave an example is kind of a specific fixed interest, but the trust itself might be discretionary. and it's just bound by this one limitation. So we see those interchanging a little bit. Constructive trust is kind of completely different, but really just because it's not a formal trust. So it generally doesn't have a trust deed, and it comes about as a result of the actions or behaviours of people. So an example would be that I give $20,000 to my friend to look after because I'm going out into the woods hunting for 6 months and I don't want to put the cash into the bank. Now, it's clear that I haven't actually given the $20,000 for my friend, but he's holding it as a constructive trust for me. So there's no formal documentation, but really my expectation is that he doesn't spend the $20,000. Now, the reason that it's different to our other types of trusts is that if my friend did go ahead and spend that money, I would need to argue that he wasn't allowed to. And I would need to assert that there was actually this trust or this constructive trust over those assets that meant he shouldn't have spent them. So it normally comes up where parties dispute ownership because the assets are in the name of people that don't necessarily or shouldn't necessarily own those assets. So the assets are all in mum's name when really they should be in mum and dad's name. Or the assets are all in one of the siblings' names when really they should have vested in all 5 of the siblings. And that's where this constructive trust really becomes apparent. And so it's mostly in litigation and court where we see this really play out. The last type of trust that I've got up there is charitable trusts. Now, charitable trusts are unique because they can never end, whereas other trusts have to have an end date, whereas charitable trusts, they can just go on forever in perpetuity. And the other thing is that they have to have a charitable purpose. So they can't be for private benefit. They have to be for a charitable purpose. And that's governed by legislation in New Zealand. So there's general principles as to what constitutes a charitable purpose. And then depending on the nature of that charitable trust, whether it's registered as a charity, then dictates all the other tax treatment and etc. for that style of trust. But it's not something that we would see in people's private affairs. It's more something that we see in organisations such as Greenpeace or World Vision or other charities that are around that might operate as a charitable trust rather than some other form of charitable entity. And then, as I say at the bottom there, all formal trusts are governed by a trust deed that will be formally drafted, that has all the terms laid out of how that trust should be operated. But all trusts are covered under the Trusts Act 2019. So that act really does govern how trusts are baseline operating in New Zealand. Okay. So, key terms. This is my new favourite part of these presentations, which is basically that I'm going to take these key terms, our basic building blocks of a trust, and I'm going to give you some definitions because I find that even though sometimes these are not understood, people don't feel like they're allowed to ask what these mean because it's just presumed that we should know what these mean. So it's a good opportunity just to get those general definitions out. First of all is the settlor. The settlor is anyone that settles value or assets onto a trust. Now, for a traditional trust, that's going to be our original, let's say mum and dad, who settle, say, a home into the trust. Then they are the settlers. They'll also be named in the trust deed as the settlors. But those aren't necessarily the only settlors, because it might be that later one of the children transferred their property into the trust or transferred some other benefit or asset into the trust, maybe a boat. They would also be considered a settlor. So it's not limited to the person named in the trust deed that is defined as a settlor. A settlor of a trust is anyone that has transferred value in. And the reason that's important is because from a tax perspective, the trust will be treated differently and the people associated with the trust are going to be relevant if they are a settlor. So there might be a wide group of people that are actually settlors in a trust. Clear as mud? Good. Okay, so next one is trustee. Now, trustee is the person or people or entities that are holding the assets for the benefit of the beneficiaries. Okay, so in that scenario with the dog, it's me holding the $1,000. I'm serving as the trustee in that scenario. Trustees have the obligation for the day-to-day operation of the trust. So running the bank accounts, managing the properties, managing the investment portfolio, they're responsible for all of that. And what we see practically is that those people will actually appoint other professionals to assist them in executing their duties. So a good example of that would be if there's a financial portfolio of investments, then the trustees would get a financial advisor. And that advisor is the one that will manage the portfolio, report to them annually, and then the trustees use that professional guidance to make sure that they are discharging their duties of holding those assets for the benefit of the beneficiaries. So it's not that the trustees have to know everything and be experts across the board, but they do have to appropriately administer the assets of the trust and employ the professionals that they need to help them along the way. It's exactly the same way that you would get a real estate agent to help you with selling a home. You would just get the person that's a pro to do that part for you. Discretionary beneficiaries. So our discretionary beneficiaries are the people named in the trust deed as having a discretionary interest in the assets of the trust. So they're not entitled to the assets on any given day, but they are entitled to be considered. I think that's what I said before. And basically the trust can only benefit the beneficiaries of the trust. So for the lifetime of that trust, what we're expecting is that the discretionary beneficiaries are the ones that are going to benefit from those assets. And in a standard kind of mum and dad style trust, we would have mum, dad, the kids, grandkids, maybe any other trusts that those beneficiaries are also beneficiary of, all listed as discretionary beneficiaries that can get a benefit out of those trust assets. Now the final beneficiaries, generally it's not as easy to change them, but they are the ones that when the trust ends, the assets are going to be distributed to. So modern trusts in New Zealand under the Trust Act 2019, which I think moving forward I'll just call the Act, because that's just the only Act I'm going to refer to tonight. Under the Act, a trust can last for 125 years, maximum. Now prior to 2019, trusts could only last for a maximum of 80 years. So we have a lot of trusts in New Zealand with different kind of end timeframes. But if we just assumed 125 years, then at the end of 125 years, if the trust is still in existence and it still holds assets, then the final beneficiaries are who those assets will be divided amongst. Now, in my 10 years, I've never had a trust reach its end date with assets still there. So as a general principle, it's unlikely that we're ever going to rely on the final beneficiaries being the ones that are actually receiving assets. It's more likely that we're going to use our discretionary powers to distribute to the discretionary beneficiaries during the life of the trust before it gets to its end date. In principle, if a trust gets to its end date and the assets are still there, then something has gone wrong with the administration and it hasn't been dealt with when it should have been dealt with. It's just been left. So that's kind of a problem situation to be resolved. Now the appointer, they are the person or people that has the power to hire or fire trustees. It's one of the most important powers in relation to a trust. And the reason it's particularly important is because although the trustees have the day-to-day operation of the trust, the appointer has the power to determine who those trustees are. So really, they are the ones that hold the core most power in relation to the trust and have a strong obligation to act in the best interests of the beneficiaries whenever they're exercising their power. So the trust deed will generally dictate who holds the power and how that power can be wielded or operate. So whether they can hire trustees, whether they can fire trustees, what the minimum number of trustees must be, so whether it's 1, 2, more than 2. And then if anything is missing in the trust deed or it doesn't provide for who that power vests with, then there is provisions in the Act which do provide for how the power to hire and fire trustees should operate in the absence of someone named in the trust deed. So there is kind of a legal backstop if our formal documentation fails us, basically. Now the last one I've got on there is protector, which is something that generally speaking we don't use a lot of in practice. Protector is someone that is named in the trust deed and that it's generally a way of having the trustees required to consult with someone else before they make decisions. So the person who the protector is not a trustee, but there'll be certain circumstances where they need to be consulted before decisions can be made. So it tends to affect, and we don't really use it in the trusts that we create or operate, and it can be more important in, say, a high net wealth trust, very high net wealth trust, where there's a need for the trustees to operate day to day, but if they're going to make a significant financial decision, then they should talk to the head of the family, who might be named as the protector, or they should talk to the portfolio manager down at the financial advisory group that they deal with before making a major decision. So it's really a way of having an extra layer of check and balance on the trustees before decisions can be made. Generally, we would just rely on the trustees exercising their decision-making authority unanimously as a way of mitigating any risk. And for most trusts, that seems to work well, but it is a phrase that sometimes come up, so it's worth kind of knowing about just in case it's thrown around. Okay, trust powers. So we've kind of canvassed a little bit of these already just by going through the definitions, but the management of the assets, that's our trustees. So that's that day-to-day operation, looking after the trust assets. Power to hire and fire trustees, that's our appointers. The power to vary the terms of the trust, and the power to add and remove beneficiaries. So these are our two key powers of variation within the trust. Now you can see that those are separated out into two distinct power groups. And the reason for that is that it's very clear under New Zealand law and through the courts that the powers are distinct. There's a general power to change or vary the terms of the trust, and then you must have a specific power to add or remove beneficiaries. Now, my kind of interpretation of the policy reason behind that position is that the beneficiaries are fundamental to the nature of the trust, and certainty of beneficiaries is critical to whether a trust actually exists. So that list of original beneficiaries is a core term of any trust deed. So if you are going to have a power to remove any of those beneficiaries, then it must be a specific power allowing you to do that specific thing because of how critical it is to the core of the trust. And same goes for adding in new beneficiaries, because effectively what we're saying is, my friend has told me to use $1,000 to benefit his dog, and then whilst he's overseas, he also decides that he's happy for me to use $1,000 to benefit his neighbour's cat. So now the original purpose of the trust, which was to solely benefit the dog, is now effectively being undermined by this later decision to want to benefit the cat as well. So that must be a specific power under the trust deed to allow for that kind of fundamental change in the purpose of the trust. And that's really what we're talking about when we're talking about the beneficiary list. That ties in heavily with the original purpose for why a trust was set up. It's to benefit those people, not to benefit the neighbour down the road or Bob at work. It's to benefit this specific group of people. Now, the general power to vary a trust is going to cover the rest of the terms of the trust, but it still might have other restrictions. So an example of that would be in the LOA law trust deed that we prepare, there is a requirement that trustees act unanimously. So they have to make decisions all together. And our power to vary the terms of trust clause specifically states that that term cannot be changed. So even though the terms of the trust can be altered, that specific term is unalterable. And that is partly to protect the trust from, in the future, its strength being eroded and that being changed to allow for different decision making. So whenever trustees or people involved in a trust are dealing with trying to change it, it's really important to read the trust deed, understand the scope of those powers, to know then what you can and can't do. And then if what you want to do is not within the powers that are in the trust deed, then you push on to the Act to see if you can get some power within the Act that doesn't conflict with your trust deed. And if there's still no power, then the only way to move forward is to go through the High Court. And the High Court has the jurisdiction over trusts in New Zealand. So any litigation that relates to trusts must start in the High Court. And there's a number of ways that they will deal with matters relating to trusts. Now, under the new Act, there's actually provisions that allow the court to vary the terms of the trust if all of the beneficiaries have agreed. And if all the beneficiaries haven't agreed, then the court actually can either consent on behalf of the beneficiaries that don't agree, or allow for the variation to be made without all the beneficiaries agreeing and just override it. And then lastly, the court can just use what's called its inherent jurisdiction, its general ability to oversee trusts, in order to decide that yes, we are actually going to vary the terms of the trust, right? We are going to allow that action in relation to the trust. So the new Act has really clarified a lot of how that operates by having specific provisions within that piece of law to cover how trusts should work, but there's still plenty that is governed by case law of what goes through the courts. So if there's anything that ever comes up that is weird or wonderful, then it's worth talking to a lawyer to see where you stand in relation to a dispute around a trust, because there might be something you can do about it quite easily, and you might have legal rights that you don't really know about. So it's kind of it's a important element of trust management in New Zealand that the courts do have direct oversight. Alrighty, the trust fund. Now this is a term that gets bandied around. First important fact is that the trust fund refers to the totality of the trust assets, both actual assets and liabilities. So when we're talking about the trust fund, we're really talking about actual assets and the liabilities of the trust, and the total cumulative of that. Now the assets can go in at any time into a trust. When a trust is formed, you'll have your initial settlement onto the trust, and often in New Zealand trusts, like mum and dad trusts, that's going to be the transfer of a family home or some other significant single asset, maybe a large cash investment portfolio, something like that, going into the trust. But then at any point at a later date, further assets can be transferred into a trust. And there's a few ways that we achieve that. So one is by gifting the assets into a trust. So that's basically where I just say I gift my house to the trust, and now the trust owns my house. The second option is to sell the asset into a trust. So I would sell my home to the trust, and then the trust would owe me the purchase price. Say I sell it for $500,000, the trust then owes me $500,000. And that's one way of getting assets in whilst I still have $500,000 owed to me. And then we would need to gift that away if we truly wanted to break the relationship between me personally and the asset going into the trust. Now that's something that might have tax implications or be part of a broader restructure. So it's definitely worth talking about properly with your accountant and your lawyer before you make any moves around moving assets in that way. And the last one I've got up on there, the last major one, is distributions by will. And that's just a classic, I leave everything that I own to the Simon Jenga Family Trust. And then by operation of my will, anything that's in my personal name would push into the trust that I've selected in my will. And then those assets would be distributed to beneficiaries of that trust from there, rather than directly through my will, that's something we see fairly common for people that have a trust structure in their life. Now there's different ways of getting assets out of a trust or disposing of assets. So the first one is loan repayments. The trust has assets, but it also owes money to someone else. Then it can obviously repay those loans just in the normal, ordinary way that someone would if they owe a debt. Distributions of capital. Trust has $100,000 and it decides to distribute that $100,000 to one of the kids to help them purchase a home. That distribution is just going straight out to that beneficiary of the trust. Allocation of income to beneficiary. That's effectively where the trust earns income, and then instead of realising it at the trust level, it being taxed and then adding to the capital of the trust can push that income straight through to beneficiaries to be taxed at the beneficiary level and then part of their capital. That is 100% requiring accounting advice and outside the scope of ordinarily what us lawyers would get involved in advising on. So that's where that good kind of teamwork with a good accountant is super important when managing a trust. And the last one I've got up on there is resettlement of assets onto a new trust. So, and that is something we would often use where a trust that is in existence is either no longer serving the purpose that it was set up to serve, or its terms are too restrictive, and so it's not operating correctly. So like an example of that might be if a trust was set up and it's got mum and dad and the kids as beneficiaries, but for some reason has that you cannot add any more beneficiaries and it doesn't have the grandkids as beneficiaries. And mum and dad have now died, leaving just the kids, and they've now got kids, and the parents, the kids are starting to die, but there's no way of getting the assets down to the grandkids because this trust doesn't have them as beneficiaries. So if we were able to resettle those assets onto a brand new trust on modern terms that included the grandchildren as beneficiaries, then that's going to extend the life of this legal structure, this legal relationship, so that those trust assets can be used for their true ultimate purpose, which is to benefit the family down the lineage. So it's a way of restructuring the trust affairs and trying to do it in ways that align with our original settlers' overall intentions. Now, one that I don't have up on there is loans out to beneficiaries, which probably should be on that list and is fairly common these days with the bank of mum and dad, and giving money to kids in order to purchase property. And instead of a distribution, one of the ways to do that is to actually do a loan out to the kids. So rather than the money going out, you loan $100,000 to your child who's a beneficiary of the trust. They use that money to buy a house, but that money is still ultimately protected as family money. And that's a great way of insulating from a potential relationship property issue with your children's partner or spouse, because that loan is still owed back to mum and dad's trust. So if anything ever happens with the kids' relationship breaking up, then that debt can be paid back out to the family. And of course that's going to tie in with a broader discussion on relationship property for any couple that are going through that property purchase process. And as I say at the bottom there, must consider the tax implications, both when putting assets into a trust and when dragging them out, because that is a moment in time where rights crystallise, is the way I'd phrase it. And so the moment you move an asset from one owner to another owner, that is a trigger point where tax liability can arise. So it's really critical to make sure that you get the good advice and the good oil before making that decision. Right, now we're on to the important parts of our chat, which is why to have a trust. Now, I've got a number of different reasons to have a trust up there, and everyone's circumstance is going to be different. As we're going through this, something to bear in mind is that these are the questions that I'm asking myself when I'm sitting down with a client and going through whether a trust is right for them. So this is when I'm asking questions and trying to elicit from a prospect or an existing client whether a trust is appropriate for them. This is the information, these are the questions that I'm trying to answer to then advise as to whether a trust is the right thing for them. So we're looking at protecting assets for protecting assets from future business creditors, protecting assets from future relationship property claims. Now, I've emphasised future because a lot of grumps and grizzles about trusts come about when people feel that they don't protect them from liability, like creditor liability, like relationship property claims. But in reality, they've set up the trust too late when the claim has already arisen. So a really good example of that would be Mr. and Mrs. Get into a relationship. Mrs. has a home that she owned prior to the relationship. She then decides 2 years into the relationship, actually this really should just be my home, this shouldn't be sucked up as relationship property, so I'm going to move it into a trust. And so she moves it into a trust, they stay living together in the home for another 3 years, and then they separate. And then Mrs. Client squawks about that the trust didn't protect this asset from the relationship property claim that ensues. Now the reason that it might not protect that asset is because the liability was created when the relationship began and the property was held in her personal name. So in order for the trust to have offered any kind of protection, it either needed to be that the trust was formed prior to the relationship even beginning, or that during the relationship the parties entered into a contracting out or prenup style agreement to ring fence the property as her separate property. So in either scenario, the trust is only going to add value if it is present and protecting assets before the liability has arisen. So that's critical in terms of timing, and the same goes for business liability. As soon as the liability is known, then it can be too late for the trust to be of any use. And it's only going to protect against what's happening in the future rather than what's already happened. Now the next one is to allow for certain assets to be available for the next generation. So we don't often have trusts that are just for this sole purpose. So it might be that there's a family batch that mum and dad want to keep in the family for the next generation. But often this kind of morphs into generally wanting the assets that I have to be transferred to the next generation in a seamless way that allows the most flexibility for my kids to be able to deal with. So if I have 3 kids and I have 6 commercial properties, which would be lovely, it might be that I would want my kids to keep that portfolio of investments together rather than sell it all and divvy up the capital proceeds. And so a trust can be a way of structuring your affairs so that when you're gone, that investment portfolio is geared to just carry on as is and provide an income for the next generation without too much tinkering. So it's a way of managing affairs with the expectation that it might last into the next generation. So that's kind of a really good use of them if it's set up nice and clean. Next one I've got there is managing the affairs of someone that's unable to themselves. Now this could be someone that has a mental disability and is unable to, is actually unable legally to manage their own affairs. Or it could be someone that's physically disabled and has difficulty getting out of the house, going to banks, engaging with society in the usual ways, let's say. Or it could be someone that has some other reason that they're not able to manage their affairs. Could be drug addiction, could be that they're just terrible with money, and that as soon as there's 20,000 in their bank account, that you know that it's going to be gone the next day on a trip or on a boat or on a car. And so the trust structure really should be only finding the balance necessary to support those people's lives rather than, as I say, kind of dictate how they need to live their lives in an overbearing way. Or at least that's my generally professional advice to people that I chat to. Next ones down are not necessarily reasons on their own to set up a trust. So reducing the cost burden of administration of the estate, a trust can be a way to make the transition from for someone that's died of their assets cleaner and easier. But as we kind of move into an era where a lot of people have a KiwiSaver, and probably the generation that are passing away at the moment still might not have a KiwiSaver, but that's certainly coming, that there'll be almost everyone will have a KiwiSaver, which means that as soon as there's that personal asset, then probate is required anyway. So it might be that even if there is a trust structure in place, that you still have to go through some form of estate administration in order to get assets transferred out. But it can be a way to make that process a bit easier. Reducing potential challenges to wills. Now this one is a little bit contentious at the moment. We've got some kind of recent-ish case law that casts a bit of doubt as to whether trusts are going to hold up against claims where people that have not benefited from an estate because of the trust's existence, that maybe those situations will get unwound. So that would be an example of the trust is set up to benefit the second partner or the second husband or the second wife, and then the kids from the first marriage don't get anything because there's nothing in the estate because all the assets have been transferred into this new trust. And will that hold up when mum or dad dies, that actually there's no assets, and will the assets survive in this trust against an attack around that overall structure? Now it's not obvious to me that those are all going to fall down like house of cards, but certainly we are delivering advice on a case-by-case basis these days as to whether that's an appropriate reason to set up a trust or whether there's a better way of mitigating risk of a claim. And then the last one, the last two down there, we've got rest home care costs. Traditionally, trusts have been successful in isolating assets so that they are not counted as part of the asset pool for calculating the assets that you've got available when the subsidy is being calculated. It's not obvious to me that that position will last forever, and it's certainly not a reason on its own that we would say set up a trust in order to kind of hide assets or compartmentalise assets for the purposes of the subsidy. It's just something that crops up now, and we deal with clients that are in that scenario, and potentially the trust offers a slight benefit there. And then the last one is to manage tax liability, not to avoid tax critically, which is illegal, but to be part of a broader structure, and then the trust is a vehicle that then you need to incorporate into how you are managing your tax position. And again, that's something to review with an accountant once the conversation has been had around whether a trust is appropriate for you or not. And then potentially there might be some tax optimisation that falls out the bottom of the structure that's designed to protect assets. Okay. I like this little graphic, and I don't actually know whether people online can see this graphic, but it says, "I'm sure I can trust you not to fight over my money when I'm gone." And then it has three people saying, of course, with weapons behind their back. Now, disputes over money get messy, family disputes get messy. We like to think the old slogan, "they would never do that," comes out a lot in my office, but in reality, they do that. And not all the time, but when it does happen, it happens, and it goes sideways super quick. So trusts are a way of holding assets, and because of their discretionary nature, it makes it more difficult for the next generation to legitimately squabble over what they did and didn't get, because there might not be actually a legal basis for them to fight. And that means that you might avoid some uncomfortable family situations by utilising that flexibility in creative ways, basically. With a will, you've got fixed rights. I leave 1/10 of my estate to my daughter, I leave 9/10 of my estate to my son. Fixed rights that are suable. Can the daughter sue? The other thing that people have to take into account is that when they start dividing things unequally between family members, is that it's the people that are left behind that have to deal with that. So it's not dad who's passed away, it's the three children, and one of them is getting 90% and the other two are getting 5% each, and they're the ones that have to deal with that, not just mechanically, but also in the sense of, do they have an equal relationship amongst themselves? If they do, can the one that gets 90% really stomach that they're getting that, or would they rather just transfer 25% more to each of their siblings in order to balance it out? So whenever you're structuring your affairs in that way, whether it's a trust or otherwise, it has to take into account the practical reality of what the family is likely to do when you're gone, because otherwise it's just been a waste of time. So setting up a structure that's going to work, and unlike this chap, kind of having your eyes wide open to the potential problems that might arise within the family, that's critical to then know whether a trust is the right vehicle to assist with achieving that goal or not. Now the last thing is the timing for trust formation. This quote is a quote that got told to me by my now business partner, but at the time he was my boss, and it was when I was early in my days of practicing, and it's basically that the best time to plant a walnut tree was 20 years ago, the second best time is today. And the same goes for trusts. So, and what does that mean? It really just means a trust that has been well managed, run correctly, had assets transferred into it in appropriate ways with the correct documentation, that has history, is going to serve protectively to make sure that your assets are protected from unwanted liability. And the longer there is of that history, the better for that trust. The longer the assets have been away from you personally and held in this separate entity, the better it is. Now, if you don't have that, the next best thing you can do is start your asset protection journey today. And particularly if on our list of reasons to have a trust, that there's a legitimate reason that a trust would be beneficial to you, then it might have been better to have it a few years ago, but today might be better than 3 weeks from now or 6 months from now. So it's about looking at whether a trust is actually necessary and then making decisions from there, rather than my mate next door has a trust, I should probably get a trust because then it will look like I'm upper middle class New Zealand. Like, that's just such a silly way to look at personal structuring, which in my opinion happens too often, that we're too fixated on what other people are doing rather than just what's going to benefit us. And therefore, you know, when I'm going through that list of reasons, if the conclusion is that there's no benefit for a trust for a client right now, then that's the advice. And then it's up to the client to consider themselves on their own risk continuum. And I would do it. And I don't have a whiteboard, but like if I was to use this board and we had like low risk, high risk, and low likelihood of happening and high likelihood of happening, then like up here would be high risk, high likelihood of happening, which would be an opportunity that someone would want to mitigate that risk probably, and they would spend more money and more time and put in more structure to make sure that their assets are protected. But if they're living a life of low risk and it's low likelihood that anything is going to crop up, then they might not need a trust or a company or a broader structure protecting their assets, because it's unlikely that they're ever going to have a loss event. Some clients who are way down in that corner still want the Rolls Royce of asset protection because they can't go to bed at night knowing that their assets are exposed, quote unquote. Some clients who are high risk and high likelihood of something going wrong still are happy for everything to be in their personal names and seat of the pants kind of stuff, and that's how they live their life and they're not bothered. So it comes down to a personal decision rather than a right or wrong decision. But from my perspective, if a trust is appropriate, then the best time to do it if you don't already have it is now, so that you get the benefits for as long as possible. And effectively thinking of it like insurance, that it is there if it's doing its job to protect you should something go wrong. And hopefully, and this is something I say to people regularly, hopefully 20 years down the track, trust has been a complete waste of time because you never had a loss event and you never had disputes arise and you never had a creditor come along or you never had a relationship break up. And if none of those things happened, then the trust would have served no purpose because nothing has exercised whether it was necessary. But at the same time, that's like not getting fire insurance on your house and in 20 years' time saying, oh, it's good we didn't get fire insurance, that would have been a waste of money. But then if your house does burn down, well, it's a bit too late for insurance. So it's kind of, that's the attitude to take to it, I think. And that's us. So I think what we'll do is we'll leave it there for our online crew. So thank you for joining us. It's been a pleasure having you there. And we'll just crack into a bit of Q&A. Can you add other beneficiaries as additional beneficiaries of the trust? The answer is yes, you can. So, and it depends on what's in the trust deed and what powers are there. Could you, in theory, be an appointer, a trustee, and a beneficiary? Yes, you can. Yeah, and the most vulnerable trusts are ones where there's too much power consolidated in one person or a combination of people. So like the most kind of well-known case around that is a relationship property case, which is Clayton and Clayton. And that case was basically that Mr. Clayton had a whole bunch of assets in 2 trusts, and he was the appointer, the settlor, the trustee, beneficiary, primary family member or principal family member. He could transfer all the assets back to himself without owing any duties to the other beneficiaries. And there was one other power he had. I mean, it was a collider. It was a whole bundle of powers that the court said is so akin to ownership that we are going to assign the value of the assets of the trust. Those powers have the same value. And then those powers were used as relationship property. So it was quite a novel way of the court getting to a decision of trying to get into a trust, but effectively the trust was unwound by someone holding too much. Yeah.
Is it better to have an odd number of trustees?
In the sense of that if a decision needs to be made? Not really, because of the unanimous decision making. So if you have 2, then both need to agree. If you have 3, then all 3 need to agree. If you have 4, all 4 need to agree. So rather than majority rules, and some trustees do have majority, and I don't like it, and we as a firm I'm kind of binding my co-directors, I think, on this, but I think this is right, is that we would not serve as trustee on a trust that has majority decision making. Because if it was mum and dad and our independent trustee, then effectively mum and dad could always just outvote us. So if we said, no, this is not within the bounds of what we're comfortable with, then mum and dad could just say, well, we've both agreed that it is. And so we wouldn't serve in that scenario. They are out there, but so generally speaking, you're still going to want the unanimous, which means as long as you've got more than one, that's the critical element.
What's involved in winding up a trust?
Depends on what's in the trust, around what is required to shut it down. But in general, there's 2 core documents. One is a deed of distribution, and because as I said, we don't really want the trust to end with assets still in it. So the first thing we want to do is ascertain what assets there actually are in the trust, and then we want to deal with those assets before we bring the trust to an end. So we want to distribute those out. So if it's mum and dad that are winding up the trust, then we probably want to distribute the assets back out to mum and dad first and leave the trust as an empty shell, and then do the deed to wind up the trust. And generally that involves, what we would do is we'd bring forward the distribution date or the vesting day or the end date of the trust, and we would drag that forward so that the trust comes to an end earlier, basically. And then depending what assets are in there, just dictates what other mechanical documents are required. Does that make sense?
Yep. But it can be done.
Yep, it can be done. And some trusts, I don't think I've come across a trust. I lie, I've come across one trust that we technically were not able to bring it to an end earlier. But other than that, I haven't come across a trust where we couldn't get the assets out and or bring the trust to an end early. So it's dictated by the terms of the trust deed is the critical thing, but most trust deeds allow for those 2 actions.
If there is more than one settlor, do they have to agree?
Yeah, any decision that's that fundamental to the trust will generally have it that they have to both agree. It will be governed by the trust deed, but I would expect most trust deeds would require everyone, and particularly because they're probably both trustees. So because they're both trustees, then they would both need to agree. Yeah.
What are the main pros and cons when looking at buying an investment property in a trust or a company?
I would say the best structure to purchase an investment property is probably in a company with the trust as the shareholder. So rather than one or the other, it's probably to do it in that way. Now, there's a couple of reasons for that. Now, number one reason for the company being the owner of the rental property rather than the trust is that a company has the added benefit of limited liability in relation to particular liability and particular debts. So although it might not crop up day to day in respect of rental properties, it is something that is quite a good position to start out from, that you've got the benefit of potential limited liability, whereas trustees are personally liable for the debts of the trust. So if the trust owns the rental property and a debt arises and it can't be satisfied by the assets of the trust, then the trustees personally are going to be on the hook. So that's kind of reason number one, is a bit of an asset protection reason. And the second reason is flipping it around in terms of what I suggested of a company that's owned by the trust, has shares owned by the trust, is because what is ideal is to create wealth, if you have a trust structure, is to create wealth in that trust. So you don't want to build wealth in your personal name. So you don't want a company that has you as the shareholder personally, because the shareholders are the ones that hold the value of that company. So effectively, you personally hold the value of that company. If the trust is the one that's the shareholder, then that value is held in the trust, which is really where you want to sink your wealth. And then if your family home is there as well, then the trust now has as your little wealth pool the family home and the value of the rental property through the shares that it owns in the company. And that's a way, and then any capital gain on either of those properties is now sinking into the trust rather than into you personally. So that dual layer is, I think, the best way to do it. Comes with a little bit of extra cost at setup time, but in my view, it'd be worth it for long term, and particularly for if you are starting out on an investment journey and you're wanting to build a structure that's going to last you the next 40 years, then having something, you know what it's like? It's like sledgehammer on walnut. You know, it might be a lot of structure for now, but if you get 3 or 4 investment properties, then suddenly that's real just nice fit for purpose. So it's anticipating whether you need that level of structure or whether something simpler is going to do the trick.
How old do you have to be to set up a trust?
To be the person that actually sets it up, need to be 18. Yeah, but to be a beneficiary of the trust, you can be any age. So like for example, I could set up a brand new trust that is the sole beneficiaries are my 2 daughters. Like I could do that if I wanted to, even though they're infants. They could be the sole beneficiaries of that trust. And it's just then about how to distribute assets. And generally you distribute assets to guardians for infant beneficiaries. And by infant, I mean under 18. So then it goes to their guardian rather than to them directly. And then it's only once they clock out that then they can receive distributions direct.
When someone's will distributes their house one way and their trust distributes the house another, how does that get resolved?
Yes, this comes up. Now, it generally comes up when the legal advisor that is running the trust is not the same legal advisor that has advised on the will and broader estate planning. So it's a really good example of you need those two to be talking to each other. So the core documents that should be talking to each other are the trust deed, the letter of wishes. So that's what is the settlor's intentions for the trust. So that's important, and then the will. And those 3 documents, they need to be nicely lining up. So in the scenario where the asset is already in the trust, and the will says, I leave everything to each other, failing that to the kids, effectively, the house just is no longer part of that will disposal because it's not owned by them. So you can only dispose of what you actually own in your will. So I can't, in my will, say I give the statue of Harry McCleary dogs in downtown Tauranga to my 2 girls when I pass away. So I can have that in my will, but it won't be effective. So anything in a will that is not yours at the date you die, it just fails. And like we see that all the time, less in that scenario where people haven't updated their affairs, mainly because I would say at LOA we wouldn't let that be the way those documents are put together. We'd make sure that they're all talking to each other, so it's just something we don't see at the back end because hopefully we've dealt with it earlier. But what we do see is things like I leave my painting of the Endeavour to my niece, but during their lifetime they gave that painting to their neighbour. And then they might leave their wedding band to their daughter, but during their lifetime they gave the wedding band to their granddaughter. So at the date they died, they didn't actually own that thing, therefore that gift in their will just fails. It's not like you go to the granddaughter and you go yoink and give it to the daughter. It's just, it's already gone. Yeah. And that does come up with people that put specific gifts in their will, but then later it's changed or they've sold it. You know, the other one is I give my car to William, and then but by the time they die, the car's been long sold, and so then it just fails. It's not like William would get the value of the car it would just fail as a gift. So that's really important. And kind of our next presentation that we're going to be doing is on wills. And so that we'll deep dive into a bit more of how that all fits together.
What if my children live overseas when it's time to distribute trust assets?
It certainly is a consideration. And we see it more and more with Australia. Australia has different treatment of trusts. And so if children have moved to Australia and their parents have a trust in New Zealand, when the parents die, the treatment in Australia, distributions from trusts are taxed in different ways than here. So here that distribution wouldn't be taxed. In Australia that distribution might be taxed. But if it was just in their personal names and it was a distribution through a will, it wouldn't be taxed in Australia. So there's potential significant difference of position for a child who is living in Australia versus children living in New Zealand, depending on how mum and dad have structured their affairs. Now, as a general proposition, it's important that people manage their affairs for their benefit first, not to mitigate potential tax liability on their assets that are going to get distributed to their children. So if mum and dad have a legitimate reason for needing a trust structure, let's say, I would probably never advise them to get rid of that structure because their son living in Australia might get hit with a tax bill in 20 years' time when they die. It's more important, and that's how I would lay it out, and it's up to the client to decide whether this potential saving for the son is worth introducing risk into their own lives by getting rid of a structure that's protecting them. So it's about just going through it. With the UK, it's slightly more complicated because we have less institutional knowledge around how it works over in the UK. It's definitely something that's worth considering, particularly if the kids are planning on going back. But one of the other considerations is that if the kids are here now, then the structure can be put in place and it can always be changed in the future. So it's about deciding what's best with the information you've got at the moment for what you're dealing with in front of you, and then making decisions from there, from a position of power.
Do I have to be a citizen to have a trust in New Zealand?
As a general proposition, no. Being a citizen is not critical to whether you have or haven't had trust. I presume you're a permanent resident here in New Zealand? Yep, so that's fine.
Is a trust still helpful when applying for a rest home subsidy?
Okay, so the reason it's still on there is because a lot of trusts that have been set up for many years are still going to be able to get the benefit of assets being protected from being included in the calculation. What happened is that there's this $27,000 a year gifting limit. You can only gift $27,000 a year. And if you gift over $27,000 a year, then that over gifting is included as an asset today. And what they say is that you have deprived yourselves of assets deliberately, and now you're trying to get money off the taxpayer, and that's naughty, and we're not going to let you do that. Right? That's the basic, simplified, but that's the guts of it. So they say you can't gift $500,000 to your trust and then claim poverty. That's how it's kind of looking, right? So anything over that 27,000 mark is considered to be asset deprivation and is now included. So if you did a bulk gift of 500,000 15 years ago, that is included as part of your asset pool, and the asset limit is 200,000 or 250,000. So you're way over, so you're not going to get the subsidy. So a trust that has historical bulk gifting is going to be unlikely to get the benefit of asset protection from the subsidy because it will just be seen as asset deprivation and therefore it won't qualify. If the trust doesn't have bulk gifting and it's stuck to the 27,000 a year, then it still can get the benefit of that. And the big weakening for those trusts is that any income the trust is currently earning is generally WINs are going to want an explanation as to why that is not being used in order to fund the care. And we are seeing reasonable divisions of that income, partially to cover care, partially for then the subsidy to kick in, or for, that's all part of the discussion with WINs at that point around what that looks like. But that there is a weakening there. So it's still something that if you have a trust and certain parameters apply, then it might still be a benefit, but it's certainly not a reason that we would say set up a trust to hide your assets from the subsidy. And fundamentally, I can explain it from a technical point of view, which is that houses today are worth, let's say, $1 million versus 70,000 in the early 90s. So let's say a house that you bought for 70,000 in the early 90s and 27,000 a year you were allowed to gift. So even if you did the whole thing on cash and then pushed the whole thing into your trust, it would take a walloping 3 years to gift that whole lot off. And then the trust would now own that asset, you'd be within the rules, and all of the capital gains that you've got on that property are now in the trust and you're totally fine. Today, $1 million property, purchased, transferred to a trust, all cash, so 27,000 a year, so for 40 years of gifting, roughly. So 40 years of gifting. So if I'm 32 now, then I'm going to be gifting until I'm 72, just to get that one asset in. And the whole time I'm gifting, only 27,000 a year is protected. So after 10 years, 270,000 is protected, and 630,000 or 730,000 is still vulnerable to creditors. So if the trust is there to serve me as an asset protection measure, it's not doing its job. And trying to preserve my position in relation to the subsidy is so not worth the other benefits that I'm doing the trust for. So practically, it's just not worth doing for the modern client, basically. Yeah. Good. Alrighty. Well, thank you for coming out.
Thank you for watching or listening, and I hope you've taken something away that's of value to you. If you've enjoyed what you've heard, hit that like button and subscribe to our channel to stay up to date with future legal chats. If you want to join the conversation, then make sure you leave a comment in the comments section. And I look forward to bringing you future legal chats. Because remember, at LOA Law, we are good lawyers for good people.